Hello everyone and welcome back to our video newsletter. In this video I want to talk to you about the Marchman Act and where your loved one can go to treatment. So as I've mentioned in other videos, the Marchman Act is two steps. The first step is the period of assessment and the second step is the period of treatment. So if the person is not assessed, and that can be done on a voluntary basis or an involuntary basis, if there's no assessment, there can be no treatment. The statute requires that an assessment be provided to the court. Well, if you're coming to us for a Marchman Act, that's because the person is not willing to go. In other words, they're not willing to go voluntarily. And so that assessment period has to be initiated on an involuntary basis. So that involuntary assessment and where that case is initiated is going to be determined by the county in which the person is physically located at the time we go to file the case. So if they're located in Palm Beach County, I file in Palm Beach. If it's Broward, I file in Broward County. If it's Miami-Dade, well, I file down there. If it's the west coast of Florida or northern Florida, then I'm going to file in that particular county. So once that assessment has been done, then families say to me, well, I don't want them to go to treatment in that particular county because, well, there's no good facilities, or my insurance only covers XYZ facilities, and well, those facilities, the ones I have a choice of, they're in other counties. My insurance won't pay for the one that's in the county where they are physically located, but it will pay for a treatment center that's in another part of the state. And then they say, well, Mark, can you send my loved one there? Can you get the judge to do that? And the answer to that is yes, I can. So the assessment period is going to be done within the county in which they're physically located, okay? And the reason for that is that 99 times out of 100, I'm initiating that assessment order on an emergency basis, which means there's going to be no hearing. We're going to get a court order, and then the police are going to come pick up your loved one and take them to a facility to be assessed. Now, as a general rule, the police will not cross county lines. They're not a taxi service, and they're not going to transport somebody to another county for a period of assessment. Okay, so that period of assessment is going to be done in the county in which they're physically located. But then we have a hearing. So the hearing is to get your loved one ordered into treatment. We have to have a hearing at that point. I can't do that on an emergency basis. I can't do that without them having a right to challenge the allegations that have been made against them. So we go to the treatment services hearing, and presuming that we win it, the judge then says to me, Mr. Astor, where do you want this person to go to treatment? And I'm going to say, Your Honor, I want them to go to this facility. That's the one that's covered by insurance. That's the one that's clinically appropriate. That's where they want to go, where the parents want them to go, or the spouse wants them to go, or the siblings want them to go. At that point, it doesn't matter, in terms of which county it is. I just need to tell the judge that, that's where they're going to go. And, as a general rule, unless there's a legal reason why the person shouldn't go there, or they have some clinically appropriate facility in another county that they are willing to submit to the court, they're going to get ordered to go to that facility. So to sum it up, assessment period done in the county where they're physically located. Treatment can be done in another county provided that it's clinically appropriate and it meets the level of care that's been recommended in the assessment. With that said, I hope that helps. Remember, we always give a free consult. Feel free to reach out to us. Take care and be well.